It's with great honor that I get to introduce Ron Barron here. This guy's like family to me. In his 30 years of practice, founding partner Ron Barron has developed extensive knowledge in acquiring and enforcing intellectual property rights of investors at all stages of technology development. His personal experiences in technology are wide-ranging, including the chemical arts, pharmaceuticals, and pharmaceutical delivery systems, petroleum processing, the mechanical arts, three-dimensional imaging, and electrical and software applications in manufacturing, and in the medical arts as well as others. He is widely published in journals and law reviews on critical topics relating to intellectual property and lecture before academics and business organizations. Ron has served as a U.S. Army officer in the Signal Corps from 1970 to 1975. So, like I said earlier, this is going to be really cool because he's going to be talking about ideas related to software development. And so we felt this was a really nice addition to this. He comes here all the way from the East Coast, so please put your hands together for Ronald Barron.
Thank you. Okay, is this going? Great. All right. Good afternoon, everybody. Thank you very much for having me here. I had the opportunity to have to visit another client of ours in used to be in Carthage, and now they're in Springfield. So I was able to put it together with another trip. And when I was talking to Mike about it, I said, there's so many areas of intellectual property law that apply that it actually affects every aspect of anybody that's thinking about going into business of any kind with any technology. Basically, it's one of the bases for monetizing what you develop. So if you want to reap the fruits of your efforts, intellectual property law happens to be something that you really should pay attention or at least know about. And then when you get where you have to do something about it, or you think you should, or you're worried about it, then you'll get deeper into it. But just quickly about myself, I'm from Missouri originally. I grew up in Jeff City with Michael's father-in-law, my brother Roger. And when I graduated from high school, I went out to the United States Military Academy at West Point and went through that and graduated, got my degree, got my bars, and went off and spent 5 years as a Signal Corps officer. And during that time, I worked in Germany in the Army Area Signal Battalion, and then we procured, I was a member of an agency, a civilian and a military agency in New Jersey that procured and installed strategic communications equipment. Then I went off to law school and then started working in a patent firm in 1975. So I've been in it ever since I got out of the Army. But, all right, so I'm going to try to stuff 30 years into 1.5 hour. Yeah. And hopefully we'll get a little bit to tell you about in the software area, which is really what you're interested in. But all of these aspects of intellectual property law really do affect you, and you should be aware of them. So, without further ado, so what is intellectual property? Well, it's a fancy word for patents, trademarks, trade secrets. By trademarks, I also include trade dress and copyrights, and they all work together. They have different aspects that they protect. Sometimes they overlap, but for the most part, they come from different ideas, and they come from different philosophies of the law, and you should know about them. So I'm going to try to go into each very, very briefly, and like I said, we ended up talking about software mostly. So what is a patent? A patent is a contract between the United States and an inventor or inventors by which the inventors agree to disclose the nature of their invention to one skilled in the art so they could reproduce the invention. So they have to disclose it. That's what you would have to do. In return for that, the United States government gives them a right to restrict others from making, using, or selling in the United States or importing into the United States whatever their patent covers. So there's a, pardon the expression, there's a quid pro quo there. The inventor has to give up the technology in a way that a person skilled in that same art can reproduce it, and the government says, we'll prevent anybody else, by using the courts, we'll prevent anybody else from making, using, or selling the same thing. There's three kind of patents, basically: utility, design, and provisional, which is really a type of a utility patent. But a utility patent is the kind that you normally consider when you consider patents. This is what it looks like. I have a bunch of these, and after this afternoon, I'll have those available if you want to look at them. And also I have about 20 copies, hard copies of this, if you want to get a hard copy of the presentation. So, all right. Why patent? Why do you want to get a patent? Well, offensive purposes gives you exclusivity, competitive advantage, licensing. You can negotiate licenses. Let's say you have technology which is close to another company's technology, and you don't necessarily want to partner with them, but maybe you want to compete with them in a friendly atmosphere, and you could cross-license if they have patents and you have patents. But if you have patents, you have an advantage. And as a result of that, you can also get income. You can get royalties. Of course, if you have to enforce the patent, you can go to court, so it gives you the basis for litigation. And it creates a positive image about your company, and it gives you additional assets for investors, and that's a big deal. Let's say you get your company to a certain level, and you'd like to exit it. You have an exit strategy, and you want to sell it to somebody. Well, you have a raft of patents, then you have additional assets that you have. And for defensive purposes, protect areas of technology, even if you don't use it. You do not need to use the technology that's covered by the patent in order for you to maintain the patent or enforce it. And that's important, because in other parts of the world, you do have to use it. And then, of course, cross-licensing, which is, I kind of talked about that before. So, patent eligible subject. There's three basic requirements for patentability. The first one happens to be patent eligible subject matter. Is your technology the nature of which is entitled to get a patent under the U.S. patent law? And basically what that section of the patent law says, is it a new process? That's one. Is it a new machine? Is it a new manufacturer? Now, manufacturer, by that they mean article of commerce or a product. Or is it a composition of matter? Now, when you think about process, if you notice now, computer programs are not mentioned in this. So that's probably because it was written before computer programs were in the prominence that they are now. But if you look at the word process can mean a process of making something or a process of using something. So process could be probably interpreted, and it usually is interpreted, to include some aspects of computer programming. So it has to be patentable, and I'm going to talk later about it, but one of the biggest problems about software patenting is, of course, getting it to be patentable, eligible subject matter. It has to be new, it has to be novel, and it has to be unobvious. Unobvious means that considering all the art that exists at that particular time, whether it be patent art or publications or online or somewhere in existence that a person can get a hold of, whether or not the advance that you have or the inventors have is such that it's not obvious in view of all that. So it can't be the next logical step. If it's the next logical step, that's good for you, but it's not good for patenting. So we have problems with that in universities, because none of the inventors in universities want to upset their colleagues. They want to let their colleagues know that they're doing the next rational thing, when in fact rationality takes away from the unobviousness argument. And finally, it has to be submitted in a patent application that discloses it so that one skilled in the art can reproduce it. So that's what happens. You got to go to somebody who knows how to put that together. That's us. And we put it together in such a way that it's acceptable to the U.S. patent examiner. So where should you patent? Well, patents are geographical, so you can only enforce a patent in the country in which you want to use it. A U.S. patent doesn't apply in Canada, and a U.S. patent doesn't apply in Mexico. You want to get a Mexican patent, you have to file there. Canada, you got to file there, or in Europe. And there is no European patent, but you can file a European patent application and prosecute it one place, and you can get most of Europe, pretty much all of Europe, and then you go into the countries after that. So if you want to enforce in Japan, you got to file in Japan. So it can get very expensive. There is a the big deal about patenting is that you get a date, you want to get a date of filing your application so that you can cut off the consideration of prior art. So that's a big deal, especially on a hot technology. You want to establish a date so that everything that comes before that doesn't include, as soon as you're on file, it doesn't include anything that comes after that. So there is some forgiveness. You can take 12 months in most countries, and you could file in the United States, let's say on January 1 of 2020, and you have 12 months to file in other countries and get January 1st, 2020 as your filing date. So that's an advantage. And you can spread that out a little bit too by filing what's called a patent cooperation treaty patent, which is called a PCT patent, and that gives you an additional 18 months. But it's very expensive, and that's something you have to be careful of. So. Okay, trade secrets. Let's quickly jump to trade secrets. Trade secrets are just, simply stated, it's information used in a business to give commercial advantage over competitors who do not have the same information. Very broad definition. There's no time limit of protection, and you don't have the requirement that it's patent-eligible subject matter. It doesn't have to be unobvious, and you don't have to write it up in a patent application and submit it to anybody. So you don't have all those requirements of an invention under the patent statute. You can simply protect it by keeping it a secret. So for example, the Coca-Cola original formula is a trade secret, and it's never been reverse engineered, and so it's maintained as a trade secret. Your industry does not really lend itself to trade secrets as much. Simply because most of what you folks are going to do, in the not too distant future, is going to be available to people in the industry or not elsewhere. And if they can reverse engineer it or look at your code and find out what's going on and reproduce it, they're entitled to, because it's just not a secret. That's the key to the trade secret protection. Examples of this, of course, is a formula, a chemical compound, manufacturing process, method of treating or preserving materials, pattern for making goods, modification to machines. You may get involved in that. You may want to keep it a trade secret. Customer lists and vendors lists. Those are trade secrets and can be maintained as trade secrets. So those can become important. If over the years that you're developing relationships with people who are customers or vendors, and you have inside information, make sure you keep it under lock and key and take trade secret protection, and you can find out what that is, and then you can protect it down the road. I've done a lot of interesting trade secrets cases where people copied the blueprints, took them out, and started competing with the people they took it from, and we had to take them to court. And the judge, they took the blueprint, and he took the new drawing and put them up. They lined up exactly. He says, "I think you better settle this case." So, but it's interesting. So some disadvantages of trade secret: once disclosed to the public, you got loss of protection. No protection against a later independent discovery. So, if I'm sitting in New York and I come up with a piece of software and it's great stuff, and I think I want to protect it, or there's something about it I want to protect, and somebody comes up with the same thing in a different part of the country, I don't have any protection against that person. They get to use it as well as I do. So, and when you enforce your IP rights, if you go against the only recourse is against the thief of the trade secrets. Sometimes if he or she goes to a company, you could go after the company and say there was some collaboration, collusion, and if you can establish that, you might be able to get the company involved. But generally speaking, your recourses are only against the trade secret thief. So, okay, trademarks. Trademarks are simply a word, name, symbol, or combination used by manufacturer merchant to identify the goods or services and to distinguish its goods and services from those of others. This identifies a source, so you know that it's a well-known source. It assures the quality, especially if the source has a reputation of having a quality product. Dell, whatever it is in the industry that you know is good, and as printers or whatever hardware that you go there because of the the source is good and that the product is going to be of good quality, and it secures primacy in advertising. If somebody goes out and, for example, the the logo that I put up, SGF Devs. You know, if somebody goes up and puts SFG up there, and let's say we were saying that's a trademark or a service mark for, we could go after that person because it's close enough that they shouldn't have the ability to put something that close on the internet or to advertise that way. It secures your primacy in advertising. So that's the kind of thing trademarks can protect you. It's really unfair competition more than it is, strictly speaking, intellectual property. Intellectual property is a product of your brain. Trade secrets and trade protection of trade names, that comes from unfair competition. It's not fair that a later user of a similar mark can trade off the good name of a prior trademark establisher, if you will. So, examples of trademarks are pretty famous. Nike, Coca-Cola, Don't Leave Home Without It, American Express, You're in Good Hands with Allstate. Colorful Natural Hairdressing knows for sure, Clairol. These are all trade secrets. These are all protectable with trade secret. And the champagne of bottled beer is Miller. So they own those taglines. Okay, now how do you protect it? Well, you can get trade secret protection, and I explained this to Mike earlier. He's already getting trade secret protection on SGF Devs simply by using it in public. Under the Lanham Act, the Unfair Competition Act, you start getting trademark rights as soon as you start using it in public in connection with goods or services. So in this case, it's a group that they provide a service. It's a group of software developers, and you get together and you have method conferences. You do other things. You collaborate. So that's you're doing a service. So just using it in commerce is the way that you initiate your ownership. Now, you know, the thing about it, you got to be a little bit careful. If there's somebody out there with a similar or confusingly similar mark that's prior to you, you don't want to get a nasty letter in the mail and have to go to court on that. So you got to be a little bit careful about using marks, but in general, if you have a mark or a logo, or you've come up with something that you want to identify your group or your products by, go ahead and use it and then sort it out later. The next thing you can do is you can register it in the United States Patent and Trademark Office, and when you do that, you get additional benefits when you go to court. You get a presumption of a valid mark, and you're going to get a preliminary injunction if you seek it. So registration is good. It's something you can do, and it's fairly, as the IP protection goes, it's fairly inexpensive, and it's easy to do. So you can also establish additional rights. Let's assume that you have a trademark and the trademark office finds that it's got some difficulties with it. Maybe it's too close to being too generic. Let's say it's too close to other aspects of the trademark law that are prevent it from being registered. If you use it for a period of time, you gain what's called secondary meaning simply by continued use in the same industry. Then you might be able to go back in and get registration, and you can enforce it. There also is a new thing out, it's not brand new, but it's a few years old. It's called intent to use application. And what that means is rather than actually using your trademark on your product because you don't know when your product's going to come out, you go to the trademark office and you say, I'm going to file this application and get a first date of first use now, and I'm going to use this thing within the next 18 months or so. And if they'll examine it, and if they pass it, then you get that. And as soon as you use your mark with your goods or your products or your services, then you can go back and say, I've now used it. You pay a fee, and they'll put you on the register. So it's one way of doing it. Common law protection is not. It's actually under the statute. Common law in the legal generic means that common law grows up by just by case decisions. They don't come up by statute. Statutes when there's a written law, whether it be state law, federal law, and then and so under the Lanham Act, they actually provide protection for common law use or common use of trademarks. So you get protection just by using. And then first use, I said that already. You can have actual first use, or you can file an intent to use application. Jump really quickly to copyrights, which is pertinent in your industry, of course. It's to protect the expression of a work, not the idea or concept. So when you get copyright protection, you're not protecting the underlying idea, you're protecting the way of expressing it. And let me give you an example that's not so technical in nature. So if you have an art class and there's 2 or 3 people in the art class and they go to a scene that's, let's say a landscape scene, a mountain, or something of that nature, and you have 3 artists painting the mountain, well, each of those artists will be entitled to copyright protection of their painting of the mountain because it's their expression of the idea. So it's separately. Same thing with, like, for example, and this happens not infrequently, stories come up, whether it be old stories or new stories, that are reduced to novels. And so you have 2 or 3 people writing about the same event or the same scenario, and they come up either with novels or biographicals, but they're different and they're written differently, they're expressed differently. Each of those authors are entitled to separate copyright protection. So in the world of computers, it comes under literary works. Of course, you can get copyright protection on musical works, dramatic works, etc. The difficulty, I think, in the copyright world as it relates to programming is that because of this requirement that it protects the expression, I'll make it very, very simple. I could take A, I could read A, I could evaluate A, I could take a picture of A, and I can multiply it times 10 and I'll get some result, X. Or, if you have that and you've got a copyright on that program, I could look at A and I could add it together 10 times and then I would get X. So I've expressed it differently. Now, the court in the early days of this change in the law, which was in the early 80s, what they tried to do is to broaden the idea of expression in the area of computer programs to say if the offending program captures the gist of the original or the protected program, then it's a copyright infringement and then would enforce it. But it's a tough one. It's stretching it a little bit. It's very specific. The copyright law is very specific about computer programs. And I'm going to give you an address you can go to, and you can, if you want to, you can actually file these things yourself and register them in the Library of Congress. So, ownership of copyright, and this is going to be important for you folks too, is that it initially vests in the author or the creator of the work. Just as and I didn't say this in the patent world, but I usually do. In the United States, the owner of every invention is in the inventor's in the beginning, okay? So when you invent something and you file for a patent, you're the owner. Same thing with copyrights. If you're a programmer and you're programming whatever it is you have and you want copyright protection adheres in you as the program provider initially. Now what happens in the patent world is generally with companies, big or small, it doesn't matter, the inventors agree to assign, that is to transfer ownership from themselves to the company. So it becomes a company asset. In the copyright world, there's this work for hire. You probably have heard of that. And work for hire is work prepared by employees whom the idea of producing the work, whatever it may be, whether it's a computer program or not, is within the scope of their employment. The other way you can do it is specifically for independent contractors. You can have a contract, but you must use the magic words work for hire in the contract. And then once again, to transfer the ownership, you could use an assignment. And so that's the way you do it. Now, I want to give this to you too, because we don't want to spend a lot of time on copyrights, but even though you own a copyright and the copyright, I have to say one more thing about this. Copyright protection starts as soon as you've reduced the idea to some tangible form or some fixed form or medium. So whether you type it into your computer or you write it down or you take a picture of it or something of that nature, anything that's reduced it to tangible form, that's when the copyright protection starts. So I just wanted to back up and touch on that. But to enforce it, you can't enforce it by just having copyright protection. You need to actually register it before you go to court, and that's a requirement. And you can register by going to this. You go to the Library of Congress. You can come to us too. We'll be happy to do it. But they're very good forms. The Copyright Office is very self-explanatory, and most people have good luck in registering their copyrights. So I would recommend that, at least in the beginning. If it gets complicated, then of course you maybe want to get some help. So, all right, software. What's a software patent? Well, there really is no such thing as a software patent per se, but I would rather refer to it as a software patent. It's really, of the categories, it's really a utility patent, and it protects the computer programs or the performance of computers, running computer programs, including user interfaces, and it probably falls more under the process as eligible, patent eligible category as any. It might be a machine, it might be manufactured, but probably processes. Software code itself is not patentable. Invention does not reside in code. So that's a little bit of an issue, and it's a problem. Architecture of a system, however, is protectable. It's patentable. How the algorithms are combined, rules, calculations, manipulations, that sort of thing, those can be patentable. It's a little bit tricky. It's you know, over the years, this has had to develop after a lot of agony in the courts and a lot of people spending money and not being successful, and then some people spending money being a little bit successful. Due to the abstract nature of software inventions, they have a higher threshold for meeting the patent eligibility requirements. Software is, the courts have looked at software in general as abstract ideas, and if the abstract idea is just made to be able to run on a general computer, that by itself will not be patentable. So you have to be careful about that. But you can get patents on your software for sure. To be patent eligible, the software must integrate the abstract idea into a practical application, and that's sort of it. And what you'll see if you look at any of the patents that I brought with me, or you go online, what you'll see, generally speaking, is that the ones that are out there now, there's some old ones that are still abstract ideas and likely to be held invalid if they went to court. But the ones that really survive are the ones that are integrated into a system and have some sort of effect. They have some sort of result. They take other things, but in doing that, it's the software that's really the driving force. I'm reminded of a patent. These are Supreme Court cases where the invention was the ability, and I think it's Firestone, I'm not too sure. It's one of the tire manufacturers. It was their ability to measure heat temperature because they were curing tires, and when you have sulfur involved, there's a problem. So they put electrodes, and they were able to measure it, and they were able to control it by software. And they got a patent because the software was the driving force, but of course they were doing something with it, and they were making tires out of sulfur-based rubber. So that's the kind of thing that can get protection. Leading case in the United States now is called this Alice Corp, and there's pages and pages and little tiny print published that give Alice guidelines in the U.S. Patent Office, and we sort of are controlled by this case. Alice involved a computer-implemented electronic escrow service for facilitating financial transactions, and it held that the software implementation was an abstract idea. The court said that the abstract idea cannot be patented merely because it was implemented on a general-purpose computer. So that's reducing about 80 pages of text into what it came out to be. So what's an abstract idea? You know, give us a hint here. Well, this is what the Patent Office says. I'm not, the Patent Office, just remember this, is not the courts. So we try to follow what the Patent Office has to say, and sometimes the Patent Office and the courts don't agree, and that can be a problem. But right now they have broken abstract ideas down into different categories. Okay, mathematical concepts, mathematical relationships, merely expressing an algorithm or calculations is going to be an abstract idea. Methods of organizing human activity, fundamental economic activity, commercial or legal interactions. There was a patent that was not held valid that was written on how to write a patent application. I was glad it was, quite honestly, was glad it was invalidated because I'd be in trouble then, you know. I didn't own a patent. Managing personal behavior, relationships between people. So for example, computer implemented treatment of an insurance claim merely on how you process the insurance claim. It would be like if you worked in, in a State Farm agency, a bureau, and you got a claim in, and you did this to it, and you took over to this person, they did that, and you process it through. Those are classically not patentable, and there's a ton of patents out there from the early days that were issued, and they're all being invalidated. So that I think is what they're talking about there. And then this is vague. It says mental process concepts formed in the human mind or by a person with the age. I mean, E equals MC squared is not patentable. I mean, it's a breakthrough. It would never pass muster in a patent law. Arrhenius equation for heat transfer across a medium. That's really smart stuff, but it's not patentable. Now, if you take that information and you integrate it into a process and come up with a result that has effect, let's say equals MC squared, and you figure out how that's going to, you use that formula for powering a nuclear submarine, you get a patent on that. So now when it comes to you and us, now all of a sudden, what do I look for? What do I do? Here's the objectives for patenting software, kind of the nuts and bolts. Identify a task, see what it needs to be done here. Describe the overall architecture of the system, especially if you have or need or will develop unique hardware. That becomes particularly helpful in the patent area. And even if you don't, and you can think of a way it would work better with a piece of new hardware, try to figure it out, and we would put it in a patent application for you. So, series of micro descriptions focusing on different calculations. That's the thing. You got to satisfy that requirement that you're disclosing it to another person skilled in the art that they can reproduce it. So you have to put it all in there. Describe each algorithm as a series of process steps with particular functionality. So as you relate the steps and you say this is how you do it, you just don't say you take this and do this. At the end of the day, you have to say why you're doing this and how it gets to some result. So a lot of that has to do with us, but it has to do with you too, because as much as we prepare these documents and we write them, it's really you folks that are doing it. So it's very, very much a collaborative process. And then critical elements for the software patent, a macro description, overall flow diagram. These are absolutely crucial. Showing the overall working of the software, a series of flow charts, not just one, showing various routines and subroutines and their complete functionality. And then finally, and this is really absolutely key, tying the software to specific modules. So, you have your different flow diagrams, and then you talk about how you're getting to certain results. Well, if you've got data or you've got different input for different reasons, or you're creating input, you have to show how that relates to each of the modules, and then it'll go right through. We have good luck with that. So you connect the function to the box on a flow chart, basically. I'm trying to keep it simple as possible. So let's see some of the ones that worked and some of the ones that didn't. These are examples of claims which do not recite a mental process and were patent eligible. Claims to a method of calculating an absolute position of a GPS receiver, an absolute time of reception of a satellite signal. So they're doing something here. It's not just a computer program, but it's computer driven, and so they're getting some result that's usable. Claim detecting suspicious activity by using network monitors and analyzing network packets. This was interesting. What it was is they were trying to figure out, they were getting, the company was getting invaded by hackers basically, and they couldn't figure out one single type of signal that could be readable and determine whether or not it was a hacker or a real signal. So what they did was they were able to put different indicia on different elements of the computer system, measure smaller bits, and combine them in such a way that they were able to identify the invaders and the real users. So. Finally, claim to a method of rendering a halftone image by comparing pixel by pixel the digital image against a blue noise mask. This is a little more equipment-oriented, machine-oriented. This is easier to understand how it would be patentable. So those are the kind of things that get out, and those are all really basically software patents. So finally, examples that claim that do recite mental process and then become patent ineligible. Claim to merely collecting information, analyzing it, displaying certain results of the analysis, and where the analysis steps are recited at a high level of generality. I mean, that's like the Bloomberg screen. I mean, that's just gathering a ton of information, putting it up there, sometimes doing brief analysis on it, but that's all it's doing. There's not getting. That's it. That's the end of it. Claim to identifying, this is interesting, head shape and applying hair designs. So they call that a mental process, that's not really that's more existing in nature kind of thing. That's not exactly a software rejection per se. Anything that has to do with like something existing in nature, and you discover it. Well, this guy, I guess, just understood how to identify head shape and then saying, well, with this head shape, you get these different hairdos that you can use. So that's more of a mental process type of rejection. Claims to comparing BRCA sequences and determining the existence of alterations. Now, that was done with software and can be done with software, but that's different. The BRCA sequences are the genes associated with breast cancer. And it was the University of Utah that developed that technology, and they got a lot of their patents were knocked out, were invalidated because a lot of them were directed just to the gene itself with nothing else, and to looking at the gene and saying, oh, there's some differences here in the story. Now, if they have taken, here's the gene, I can tell you how they could have got this to be patented. Say, here's the gene. Here's the differences, and this is how we can apply it to a method of treatment. 3 steps, and that would have been an allowable claim. They did get claims allowed and to survive the courts to replication of the genes, but not to the basic identification and the analysis that showed the differences between healthy genes and the and the BRCA genes. So. That's it. That's about it. Do you have any questions we can honor? Yeah. I can't hear that. I'm sorry. Did I?
Have you ever filed a patent in Mexico or Canada?
Oh yeah, lots of times. You know traditionally what you do. I mean, people usually file in the U.S. and then they take the application that they filed in the U.S. and you file it in Mexico. In Mexico, you have to get a translation, and in Canada, you don't because they do translate it to French, but you don't need it. They can prosecute it in English. Cost for those things that you can do. Mexico's usually we quote like $3,000 to $5,000 for Mexico because of the translation. Canada, to file one is about $1,800. So, and then you got to prosecute them in those countries. Mexico is not as rigorous. They usually, if you get a case in the U.S. allowed, Mexico will, based on that, we usually allow it. And Canada, not all the time. Canada's maybe a little stricter, yeah. So, yep. Anybody else? Okay. Yes.
You mentioned that with trade secrets, if somebody else independently comes up with it, then it's not protected. How do they determine whether they came up with it independently or they actually stole it and tweaked it?
Yeah, that's a great question. Evidence. I mean, it's discovery, and if they can determine, and that happens. People say, "Well, I did." Those cases are reported on a regular basis. Whereas independently came up with this idea, and then if they can trace it back, if they find out they can trace it back to some connection between the offending trade secret and the original one, the one that says he's original, suing based on that, then the guy will probably get in trouble. But it's all based on evidence. It's those are very rigorous cases, and there's a lot of looking in car trunks and files and file cabinets and things like that. You dig into the company, the different people's whatever they have, And nowadays, of course, the forensics we work on our computers is really quite extensive. So you have to get after them. So, yep. Did you have a question? Yeah. Yep. No, that's right. Basically nothing happens except both people had to go to court. But outside of that, if they determine that it was independently, they both have technology that they're using, and nobody gets to enforce anything against the other person. It's they're out there playing in the same sandbox together. That's it. So, okay, Michael.